Hello, everyone. We are live with yet another monthly US immigration webinar as part of our webinar series. Today's topic is H1B CAP 2026, and it's an AMA Ask Me Anything session. Today, I'm joined alongside Prashanthi. Prashanthi is an award winning immigration attorney specializing in immigration law. With over 25 years of experience, she has been an esteemed member of the American Immigration Lawyers Association and the New York Bar Association, amongst other associations as well as awards and recognitions. Prashanthi has been listed by Forbes as one of New York City's best immigration lawyers, amongst many of her achievements. On that note, Prashanthi, I would like to welcome you to carry this conversation forward.
Thanks, Vishal. Let's start with the immigration updates right away, and then we can go on to H1B registration and give them a short overview of how to do a registration since we're in the midst of the registration season, and then we'll open up the floor for questions. The questions that we got quite a few questions from our various social media channels, and hopefully we'll get some questions live as well. So let's go to the first slide. Right. So with Trump administration, with Trump coming into power, we've seen a lot of changes everywhere. Every day we hear something new. And so it's not different in the immigration space. We're hearing something new every day. And we've been seeing a lot of pushback. And it looks like the courts are the only guardrails that the present administration has, talking only about immigration as of now. So the first, the litigation that was filed, we saw that there was litigation filed for birthright citizenship as well. But recently, USCIS announced that, there were new forms. They always update their forms, but usually when they update their forms, they give you a grace period of about 3 months or so. At least a month or more than a month, so that people can, update, so that, people who are using software can update their software, because a lot of attorneys and companies use immigration software to populate their forms, and also to give enough notice period for people to start using the new forms. If you are giving no notice period, then people who have already filed, and say if there are cases that were reached on that particular day, then all those cases will be returned, and that could be thousands of cases because USCIS receives thousands of cases every day. So all the cases sent the day before or a few days before would then be returned by USCIS, and in some instances those people would fall out of status, because by the time USCIS notifies the stakeholders that the forms are returned and they send it back, sometimes a month passes by. So in that instance, then the person can fall out of status because maybe their I-94 expired, or it could be some other time-bound application which now cannot be filed because the time is over. So this is what USCIS did. USCIS announced that it required new additions for a number of forms: N400, which is for citizenship, 485, which is for adjustment of status, I-131. Vishal, I can't see the presentation anymore.
Yeah, even I'm not able to. Let me pull it back.
No, okay, there you go.
There.
As I was saying, citizenship, adjustment of status, advance parole, all those forms became ineffective immediately from the date of the announcement. So AILA sent several messages to USCIS asking if there would be a grace period for people to use these forms. There was no response, so AILA filed a lawsuit on March 7th, seeking to compel USCIS to give their stakeholders a reasonable period of time, grace period of time, to use the new forms, which has always been the norm. In response to that litigation, on March 8th itself, USCIS updated its forms website, and they gave at least a month's grace period or more for all the forms that have been issued, new versions of the forms. So, litigation still working. It works. It's just sad that we have to go through the litigation process to get USCIS to listen to anything under this new administration. Next slide. So that's the first update I wanted to give you. I also wanted to talk about removal proceedings for non-immigrant visa holders. Again, on February 28th, USCIS issued a policy memo based on Trump's executive order that an NTA would be issued. An NTA is a charging document that initiates removal proceedings. So if a person is out of status, or USCIS thinks the person is out of status, in some instances they issue a charging document called an NTA. And this was in the past never issued simply because a case was denied. So they're saying that now any non-citizen whose benefits case was denied, and if the person is not otherwise in status, an NTA will be issued, meaning that person will automatically be put into removal proceedings. So that once the NTA is issued, that means you're in removal proceedings, which means you cannot file an appeal, you cannot leave the country even, you cannot file any other form of relief. You have to go to court and do whatever you need to do in court, and that is really very problematic, because the courts are so backlogged that you will not hear anything from the court for the next 6 months, and you'll be out of status and with no means of supporting yourself, and you can't leave. So but there's an exception to this policy, and they're saying that beneficiaries of employment-based non-immigrant petitions generally will not be issued the NTA as a result of a denial or revocation of their petition. But dependent family members can be issued NTAs. So a person, a H4, if the H1 is denied, I-94 has expired because, say, you're filing an extension, and the H1 took a long time for processing, and finally when it's processed, there's a denial, and your I-94 has now expired. The H4's dependent spouses and children will get what they're saying is can be issued an NTA. But the H1 principal applicant will not be issued the NTA. The impact on this could be vast, depending on, it could be for any F1 category, like a student category, any other non-work visa category, a visitor's visa, any of these categories could be impacted. The impact depends on how seriously these NTAs are actually issued, and how to what extent this memo is implemented by USCIS. During the previous Trump administration, they had a similar kind of memo, but it was not really actively implemented. So I don't know if it will be this year. We have to wait and see. Next. This is another big change related to the to H1Bs and other visa appointments as well. There is a visa interview waiver process. It's still in place. It was started by the previous administration. Previously, the visa interview waiver process was that if you had 48 months, if your visa expired less than 48 months ago, you were eligible to a waiver of an interview. So now that has been changed. The time frame has been changed to 12 months. Also, the visa category requirement has changed. Previously, even if you had a visa in a different category and you are applying for another different visa, like you had a B2 and you're applying for a H1, the interview waiver was possible. Now you have to be applying within the same visa category to get a waiver. So you should have had a H1 and applying for an extension of your H1 visa. So that's another thing. Then the demand Obviously, with this now, the demand for the visas interview slots will go up because now they have to conduct interviews for many more people. So there'll be a longer wait time. And, there will be more vetting as well because when you have an interview process, automatically the vetting goes up. So let's wait and see what happens, but that's what we're expecting. Vishal, there's a part of the slide is being covered up by my my photograph, my video stream. Is that possible to remove that? If not, we can just continue.
Let me see. No, it looks like it's static. Yeah, this is static.
Can you move the slide? If not, that's fine. We'll just continue. As long as can the viewers see it, or the viewers also are seeing this video being
I
obscured?
think so. We'll have to check with the viewer on this, Prashanthi.
Okay. Let's move to the next slide in the meantime, and then
Okay,
maybe we
I'll
can,
look into it. Yeah.
put in a chat. As you know, the impact on existing Dropbox appointments, the impact is obvious. Now, even for people who presently have Dropbox appointments, they might suddenly see that there's a cancellation of the Dropbox appointment, and since they may now be ineligible to do a Dropbox, and they'd have to then make a face-to-face appointment, or their case might go into administrative processing because now they're ineligible for the Dropbox appointments. So I think the best thing for you to do is uh, before applying for an interview, check on your consulate website, on the embassy website. Now, unfortunately, this change was made very quietly without making any major announcements. We only saw announcements on the individual consulate websites. There was no overall announcement by Department of State. So not a lot of people didn't even know about it because who goes and checks the website, every day? You don't do that, right? So there should have been a public announcement, but that was not done. So a lot of people were caught off guard, including attorneys. So they put this in very slyly into their websites, and it's a major change. So as I said, they should have made a public announcement. Next slide. The other next update I have is for the travel bans. Trump administration is finalizing new travel bans. Last administration also, they had travel bans. Travel bans is pretty much banning people from certain countries from coming into the US. This travel ban, from what we hear, and for some people who have seen the draft, which is circulating within the executive branch, there's a proposal that there will be three different types of travel bans. One is travel bans for red travel bans for list of countries under the red list. Red list meaning that it's a complete travel ban. Last time, the travel ban was included for countries such as Cuba, Iran, North Korea, Somalia, Sudan, Syria, Venezuela, Yemen. Yemen, Pakistan, and Afghanistan may also be added this time. I think Pakistan was not there last time. So let's wait and see. Next slide. The other group of countries, there's red, orange, and yellow. In the orange group, they will not be completely stopped from coming into the US, people from those countries, but there will be extreme vetting for those countries. Or they may be barred, some people may be barred, and some people may be allowed to come, depending on the type of visa that you have. So perhaps affluent countries traveling for business, affluent people traveling for business might be allowed, but your other run-of-the-mill tourists or other non-immigrants or immigrants may not be allowed into the country based on this travel ban. People in the yellow countries, yellow list of categories, apparently for them 60 days will be given by the US government to change certain things. And if they don't change that, then they may be added to the other two lists. And if they change it, then they'll be removed from all lists. So this is a kind of a bargaining chip, I guess, that Trump is using. That is his strategy, as we all know. Try to take it to the limit and then see what he can get out of it. And then if it works, it works. Otherwise, see what the next step should be. So that's the yellow category countries, and that's expected travel bans. We're expecting this in the next few weeks. Next slide. I also wanted to touch upon the April visa bulletin. And there has been significant forward movement in the employment-based categories for EB3, mainly EB3 India and also China. So let's go and see what the changes are. You can look at the chart here, but for EB1, which has not moved, EB1 India has not moved for a while. So EB1 India has moved forward by 2 weeks. EB1 China, no change. Rest of the world, no change. EB2 India has moved forward by 1 month. EB2 China moved forward by 5 months, so moving faster than EB2 India. EB2 rest of the world, 5 weeks, moderate forward movement. EB3 India has moved forward more than EB2 India. It's moved forward by 2 months. EB3 China moved forward by 3 months. But for China, I think the maximum forward movement is EB2. EB3 rest of the world, 1 month. Huge problem with EB5s. These are the investor visas. We are suddenly seeing a retrogression. We were expecting retrogression, but not a 2 years retrogression. So EB5 China, there's a 2-year, 3-month retrogression. In EB3 India, there's a 2 years retrogression from December 2021 to November 2019. EB5 rest of the world unreserved, there's no change, it's current because that's a limited set of people, people in rural high unemployment areas. So that's, I think, will be current for some time. Next slide. So for this visa bulletin, we can expect, USCIS has said that to look at the final action date table. So if you have a priority date, which is after the date mentioned in the final action date table, you can file your 485. And for family-based cases, they're going to be looking at the dates for filing table. The dates for filing table are always a little bit more advanced than the final action date tables. What conclusion can we draw for this month's April visa bulletin? We've seen a forward movement for India, China, for EB1, EB2, and EB3 categories. EB2 China has moved forward more. EB3 India has moved forward more. Major retrogression for EB5 China and India. And for other rest of the world, we see that there's not much movement because most of those dates are current. But we will see, next slide. Predictions for the next visa bulletin for May, we're expected to see retrogression for rest of the world as well for EB5. So that's something that we need to watch out for. There's also with reference to EB2 and EB3 and EB1 as well, there is continues to be a high demand, so we don't expect much forward movement, maybe moderate forward movement in the next month for EB2 and EB3. Next slide. The other news that we wanted to bring to you, to your attention is we are expecting a government shutdown, right? Can happen as soon as May 15th if they don't come up with a plan, and it looks like the Democrats have turned down whatever the plan that the Republicans had. So it's more likely that there will be a shutdown unless they get an extension. But the good news is USCIS has confirmed that in the event of a shutdown, USCIS will continue to support H1B applications. This is very important because H1B registrations are going on right now, and there is a deadline. All the registrations have to be filed by the 24th noon EST time. So a shutdown would really cause chaos in the H1B registration space. But USCIS has not indicated that they're going to extend this further in case there are some issues because of the shutdown. Or, USCIS usually goes through technical issues on the website, especially on the last day or the last few days, because everybody's filing at that time. And usually they give an extra day or two because they have these technical issues. But let's see what happens this time. Next slide. Let's now go through some of the key elements of the H1B registration process, how to do it, what to expect, what information has to be filled out, what changes, if any, there are this year. Recent changes, there's a fee increase of $215. This is a 200% increase in fee. It was only $10 last year. It is a beneficiary-centric process now, same as last year. So only one, even if the beneficiary files several registrations, they will be only picked in the lottery. They'll be put into the lottery only once based on their passport number. We have new organizational accounts in place from last year, which are more robust, allow multiple people to log in at the same time, allow you to check for duplicates, etc. So if you have not used your my USCIS account in a while, then I suggest that what you have to do is then log into your old account and then update your account to the organizational account, because you will not be able to do registrations from your old account. If you've done registrations last year, then you would already have an organizational account. Next slide. A few other types. As I was saying, there are three types of accounts. They are applicant, petitioner, requester account that you cannot use for the H1B registration. It's for other type of filings. The attorney representative account is for attorneys. And the organizational account, formerly known as the registrant account, is the account that you need to use if you're not an attorney and you're filing. If you're not an attorney and you have to file a registration, even if you're filing through an attorney, you still have to open an organizational account for yourself, and then the attorney will link your account to their account, and that's how they file the registrations. Next slide. What is the information needed in the registration form? This is useful to know because once you get into the form, you'll be able to fill out everything at one time if you keep all this information ready. The name, of course, of the company, the DBA name as well, the federal ID number, the company's primary US office location, the legal name, title and contact information of the person signing the registration, the phone number, email address, etc. Next slide. With reference to the beneficiary, so that's all with reference to the company. With reference to beneficiary, you need their name, gender, date of birth. If they have an advanced degree, then you have to make sure that their master's degree, if you're filing under the master's category, they have a master's or higher degree from a US institution of higher education. It has to be an accredited institution. And it has to be not-for-profit or public institution. So keep that in mind. You need the beneficiary's country of birth, country of citizenship, passport, or travel document number if they don't have a passport. And please remember, your passport has to be valid at the time of doing the registration. There are no exceptions to this. In addition to that, please keep in mind that duplicate entries are not allowed, as we all know. In the registration process, if you enter the same beneficiary's name twice and submit it, then both the submissions will be invalid, so none of them will be considered for the lottery. You can have that beneficiary do a registration through another company, but you cannot file two registrations for the same company. Next slide. And in order to facilitate the prevention of duplicate registrations. USCIS in the new organizational account has a duplicate checker functionality where they can check within the draft if there's any duplicates. Sorry, they can only check within the draft and previously submitted applications if there's any duplicates, but they cannot check within the draft or within two drafts. For that, you can download, they have another tool called this, and which you can download your entire draft or several drafts into it, because a CSV file will be created, and then that way you can check duplicates. And if you do realize that you have a duplicate and you've already submitted it, if it's before March 24th, you can delete one of the registrations and then you should be okay. But if you find this out after March 24th, there's not much you can do once you've submitted the registration. Next slide. What are the trends for filing for registration this year? How many registrations are we expecting? I just pulled out a news article from the Economic Times, and they did some interviews in Hyderabad, which is a major center for registrations. A lot of registrations take place there. So registrations, they're saying, have plummeted due to, I guess, the increased fees and also maybe the H1B, the new H1B regulation. So, that's what we've heard. But let's wait and see if that's true or not, because it could be that there's a decline in frivolous registrations, but people who are still serious and have a job will still file registrations, and there is a high demand even now. That has not, the demand to come to the US, or the jobs available in the US that has not changed. So let's wait and see. Next slide. Last year, just to give you a snapshot of what happened last year, 400,000 registrations were filed, and about 100,000 registrations were picked. Duplicates were about 52,000, which is very less. Even the year before, 52,700. The year before it was 52,000. And there's a dramatic reduction in the filing of duplicates. Last year, there were about 470,000 duplicate registrations. So we saw an average of 1.06 registration per person, so almost one registration per person, so hardly any duplicates. And before that, before they came up with this new registration system, which was the year before last year, there was 1.7 duplicate registrations. So every person at least filed 2 registrations. Next slide. And also last year we had 2 lotteries. In the first lottery, we had 114,000 picks. And then, we had 13,000 picks in the next lottery. So, a total of about 130,000 registrations were picked in the last lottery. Last 2 lotteries. So let's see this year what happens. Usually there are more registrations picked than there are numbers available, because USCIS expects that some people who get picked in the lottery will not move forward with their registrations. So based on that, they pick more than they need. So it's 85,000 they need, but they usually pick 120,000, 130,000. Next. A few FAQs with reference to registrations. And, folks out there, whoever have questions, please keep your questions ready, because very soon we'll be going into the Q&A session, and the more live questions we have, the better for us. So let's see. Okay, H1B registration questions. On what web platform will USCIS host the electronic registrations this year? These FAQs actually help you file the registration, and that's why I put them here. So let's dive right into it. In order to file a registration this year, you have to go to the My USCIS online portal. And as I said, there are new organizational accounts on this portal, so make sure that you choose the right account. Can a petitioner, employer, registrant use the same email for two different MyUCIS accounts? No. You could, as a company, have two different accounts if you want maybe two different groups to do the registrations, because you have many registrations, but you have to use a separate email address, and the administrator also has to use a separate email address, because every organizational account has to have an administrator, but there has to be a separate email address used. Then you can have two different accounts. Next. If a company has multiple entities, can each entity submit a registration? Yes, you can, but remember, because it's a separate federal ID number, so it's a separate company, it's not considered to be duplicate. But remember what we know about filing registrations through different sister organizations if you're doing it for the sake of collusion to increase your chances of getting picked in the lottery, then that's a problem. But if there's a legitimate business need for each of your sister organizations, and you're filing the same for the same beneficiary because it's separate job opportunities, then it's fine. As long as you're able to prove that, then you can submit for the same beneficiary through your different sister organizations. So make sure that you're able to prove that the jobs are separate. Will any information regarding the offered position be needed as part of the H1B registration? Will an LCA be required? No. As I was told you previously, we went through what information is needed. Job title is definitely not needed. LCA approval is not needed, but it might make sense to figure out what your job title is before you do the registration, just so that you know whether your job is a specialty occupation or not. Do that research, because if you get picked and you don't file your H1 because you then realize that it's not a specialty occupation, then you would have filed a frivolous registration, and you want to avoid doing that. Next slide. That's it. So now Vishal, open up the floor for questions.
Yes. We can open up the floor for Q&A. If you have your questions and if you've joined the stream directly, you can type in your question in the comments or chat window. And for those who have joined us through various social platforms, you can put in questions directly on those platforms as well. Prashanthi, we can start with some questions that we received from our YouTube channel, and I'll take this opportunity and invite everyone who has not subscribed to our YouTube channel, please go join our YouTube channel. We post content, we post videos very, very frequently, so that you can stay in touch with us and get all the latest updates. Prashanthi, the first question we have here from YouTube is, can multiple H1B applications be applied through different consultants?
Yes, multiple H1B applications can be filed. As I was saying, a beneficiary can have more than one registration through different companies. There's no ban on that. The only ban is on colluding together, different companies colluding together to file registration for the same beneficiary for the same job, so that they can improve their chances in getting picked in the lottery. So you can definitely do it, but you have to remember that this year that there is no advantage in filing multiple registrations. You will only get one shot at the lottery even if you file multiple registrations, but you might still want to do it because maybe you're not sure whether the company A will file your H1 after getting picked. So you want to make sure that you maybe have, a backup. So if company A doesn't file, you file your H1 through company B, or maybe if both get picked, you want to file through both companies and then decide which one to use, or use one as concurrent, and the other as the initial H1.
I'll go to the next question. My category is F4. My PD is April 2007. You have any idea how much time for first step like document submission?
Yeah, so it's over a year. Your priority date is, I think the present priority date is 2006 and you're 2007. So it's impossible to say when your date will become current. F4 is the most oversubscribed family-based category. It's brother and sister category. So very difficult to say when it'll become current. I wish we had that crystal ball and we could tell you exactly when. But as you've been seeing, there hasn't been much forward movement. So it's not like every month it moves a month. So you can't say that it'll take a year. It may take several years for your category to become current, and that's when you can actually do the next steps of going for your interview at the consulate and submitting documents required.
All right. Next up, the question about where did you file for adjustment of status that was back in 2011 through an attorney. How do I know which office? Also, I was granted a waiver and then traveled outside for visa and was granted. Is that consulate that granted it? I don't want to go. I don't want out wrong info. I think that's the typo there.
Yeah.
Wrong info. If a divorce happened and green card was based on marriage, do I need to add that to the case?
So I'm presuming, first of all, that he's applying for adjustment of status again, and he's filed adjustment of status previously. In order to find out where it's filed, you just simply go to your receipt notice and it'll show you where the adjustment of status was filed. And you can include that receipt notice as well in your application. And with reference to if a divorce happened, yeah, if there is a question in the 485 form, if that's what you're filling out, as to whether you're previously married, list all your marriages and what is the present status of the marriage. So all that is there in the form. So you will be forced to add it to your case anyway.
Okay. Moving to the next one. How does the visa extension affect for an H1B with a university professor job?
If you're talking about just extending your H1B in the US, um, there is no new regulation with reference to extensions. As of now, extensions are allowed. There is, of course, some proposed changes, and there might be some new bills introduced whereby they are restricting H1B extensions to only certain people, or maybe extensions are restricted on certain basis, or restricted from a time period point of view. Instead of giving 3 years, maybe they'll give only 1 year. So we have to wait and see how that goes, and if the general H1B will be the same as H1B for university professors. So whatever law comes up for H1s in general will apply to you as well. And if we're talking about visas, which is difficult, when you say visa, it's difficult sometimes to know whether they're talking about their H1B status extension or they're talking about their visa extension. The visa extension, as I was telling you, they have the visa interview waiver. They have restricted it to 12 months, meaning if you have a visa that's less than 12 months old, only then you can apply for a waiver of the interview. Otherwise, you will have to go through an interview. Most people will not have a visa that's only 1 year, that's only been expired, for 1 year. So let's wait and see how that goes. But yeah, if again, whatever the changes are for the H1, that will affect you no matter what kind of job you're doing.
Okay. This is a long one. Um, could you please help me with your input on my case? My H1B was approved in the year 2019 and got expired in 2022. I received a 221G when I went for stamping, and the office asked me to submit my passport for stamping with the client letter, but my client did not provide me a letter, so I did not drop my passport for stamping. Hence, I never did a stamping from my previous employer. In this case, can I transfer my H1B petition to a new employer now and get my visa stamped?
Um, Under the present circumstances, you can, because it's not a transfer. You'll have to file a new H1 consular processing, but you might certainly be cap exempt under the present interpretation of what they say, who they say is cap exempt. But again, I keep telling people that could change, because the interpretation of who is cap exempt and who is not keeps changing over the years. And now they have a very liberal interpretation of it. But again, as I said, that could change. As of now, yes, you can file for a H1 consular processing, and once your H1 gets approved, you can go for your visa stamping. But my suggestion to you is to apply under this, since the registration is presently open. If you already have an employer who's willing to hire you, why not go under this registration and file for a registration under this cap season, so that way, even if some interpretation changes tomorrow, you'll not be affected. You would have been, counted towards a cap for sure. But of course, if you don't get picked in the cap, then you can go that route and file a H1 based on the previously filed H1. But remember, especially if you received a 221G, if your H1 was subsequently revoked for fraud, then you will not be cap exempt. That is for certain. So see if your H1 was revoked. If you didn't go and you didn't respond, maybe they would have revoked your H1. USCIS would have revoked it. So you need to go there and check. If it's revoked, then of course you'll have to file under this registration.
All right. So these were some of the questions from YouTube. We do have some live questions here as well, Prashanthi, so I'll go through them. First one is, I have fully utilized my H1B, which maxed out in Jan 2023. Since then, I have been on H4. Can I apply for H1B lottery 2026?
I don't see why you're subject to the lottery, Dolly. You should be cap exempt because you were previously on a H1. And if you never left the country and you're not applying for a fresh 6 years, you are still cap exempt. So you can go ahead and file a change of status from H4 to H1 without having to go through the lottery.
All right. Next one is from Rani. What to expect at the port of entry for the H1B cases approved last year for a consulting office without end client letters? Will it still be valid and the consultant allowed to enter the country? Please advise.
I mean, we can only go based on what we're hearing with other cases. But other than but as you know, because of the new H1B regulations that are now in place, the job cannot be speculative or it has to be bona fide. There has to be bona fide specialty occupation work available. And in order to show bona fide specialty occupation work, the only way to do that if you're a consulting company is by showing these end client letters, POs, and contracts to show that you have work available for your consultant. In that scenario, I have seen that increasingly both consulates as well as the port of entries are asking for these kind of documents. And I've recently heard that there was one person that was not allowed into the country because they had an in-house project, and the officer at the port of entry was not convinced that the in-house project was genuine, and therefore they thought that there was no genuine H1, and they did not allow them into the country, which they will within their authority to do so if they think that something is fraudulent. So that can be expected more and more because there is now extreme vetting at the port of entry and also at the consulates and at USCIS.
All right. Uh, Next up is Nishi's question. My H1B cap petition was filed last year while I was in India. It was approved. I have the I-797B. What do I do to activate since I am in India?
If you don't have a visa, then you have to go to get a visa based on your H1B petition. Unless you have a H1B visa previously, which is not expired, then you could travel into the US using that old visa if it's not unexpired. Otherwise, you have to go get a visa. So go apply for a visa at the consulate, which is closest to you.
Nishi shared some additional info context. Employer rescinded offer.
If the employer rescinded the office, then obviously you cannot go for a visa. But you could be considered to be cap exempt. And so if you have another employer that's willing to file your H1, you could try filing through that employer and then go for a visa with the new H1B. Also, just to be safe, I would file under the file a registration under the present registration period as well, just so that if they change their interpretation of what is cap exempt and what is not. Um, because previously they would say if you didn't actually start working on the H1, then it's not cap exempt. But now they're not saying that anymore. But they can go back to saying that it's USCIS. They can do whatever they want. No harm in doing a registration. And as I was saying previously, if you don't get picked, then try to file a cap exempt petition.
Okay. Next question is from Vashishta. After the H1B approval, how long the applicant can take time max to travel to the state with the H1B? Since the applicant travels after a delayed period, what kind of questions he or she may encounter in port of entry?
Hi, Vashishta. Thank you for your question. So the H1B, it's a very relevant question because a lot of consulting companies file for H1s and either don't send their consultants for a visa immediately because the market is not good or something has changed, or send them for a visa but ask them not to come in immediately because they're not able to support them and find, and again something has changed, some circumstances have changed. There is no I mean, obviously the maximum period within which they have to come in is the validity of their H1B, but practically speaking, the sooner they come in the better. And if there is a long delay in coming in, then they have to show at the port of entry that the job still exists. So they should carry an updated employment offer letter. They should carry updated PO, contract, work orders, and client letters to show that they actually have a job in hand.
All right. So Dolly has shared some additional insight, more details. I've completed 6 years on my H1B in 2023, and then I went on H4 EAD through my spouse. In between, I stayed in India for over a year for 390 days from April 2021 till April 2022, which is during H1B. 5 months was remaining for to be fully utilized H1B. Am I eligible for another H1B as I had a break for over a year for 390 days, or uh, still I can just go for status change as you said?
Well, now that is important information that you have given me. If you've completed your 6 years, you can still go for status change as long as you have an I-140 approved. because there has to be some basis on which you're filing for extension beyond 6 years. You can, of course, um, try to get back the period that you have not used and file the H1 only for that period as well. If there's some unused period on your H1, you can recover that as well. Otherwise, you need an I-140 approval. Or if you're trying to get 6 years and you're filing a new H1B with a new six years term, then you have to go through the lottery. In those circumstances, if you're not filing for fresh 6 years term because you spent 1 year out of the country, then you don't have to go through the lottery. But if you are doing that because you have no other way of getting a filing beyond 6 years, then you should go through the lottery. I hope that's clear.
Great, thank you. For those joining or staying with us and or streaming from other social platforms, if you have any questions, you can ask. We still have a few more minutes. And for the interest of time, I'll just continue here to add, before I go any further, I think questions are obviously a priority. So we do have some more information from Vashishta here. I'll just continue. My friend's friend has a US master's degree. He did research / a PhD in a university. He is currently in India. Should he get his H1B filing cap exempt or an H1B, EB 1B category filing, which is more appropriate?
EB1 is for a green card, and EB1 is not current. It's 2022 for Indian nationals. So if he files through EB1, number one, there is no guarantee that you will get an EB1 approved through I-140. Simply because you have a PhD, you have to show what research you did. You have to show that you excelled in your research. You have to show citations, publications, etc., etc. So that's, there's no guarantee of getting an EB1 approved. And even if you get it approved, that could take, for the I-140 to get approved, the processing time, though I know premium processing is available, but the priority date is not available, so you don't know when they can actually come in. So if they want to come into the country immediately, then H1 is the way for them to come in, not EB1. If they're not in a rush to come in and they can come in 2 or 3 years later or whenever the dates become current, then you can use the EB1 route.
All right, thank you. As you can see in the slide up, we can certainly help you. There is still a lot of you may need additional help, consultation. You can definitely reach out to us. As I mentioned during Prashanti's introduction as well, Prashanti has been in this field for a long period. She is well recognized and she comes with tons of raving reviews. You can check them out yourself on all multiple different platforms. For joining today's session, we are giving away a complimentary consulting session with Prashanti. It's an early bird, so if you are interested in applying for the complimentary session, you can drop in your email address in any of the streaming platforms, and or if you prefer to just DM us or email us, and one of our team members would be happy to reach out to you.
I think we've missed one question from Ravi R.
Yeah, I will just go back on top. I just wanted to make sure that the screen is here so that everyone can get our contact information. So that question at the very beginning was, who is exempt from H1B cap?
So that's a good question because registration is upon us, and very soon registration will be over, and then you'll know whether you're picked or not, and also whether to know whether to apply in the registration also is important, right? Whether you should or should not, like all the questions that we had. So who is exempt from H1B cap is an important question. You're exempt if you previously had a H1B approval. If you were previously on a H1, that's the interpretation that they're using right now. And there is another interpretation that you should have had the H1B within the last 6 years, but that also seems to have been done away with, and they're just saying whoever has a H1, and we're getting approvals even for people who have had a H1 approved more than 6 years ago or worked on a H1 more than 6 years ago. The strictest of interpretation is you had a H1 and you worked on the H1. That is only those people who are cap exempt. But we're using the more liberal interpretation. USCIS is using the more liberal interpretation now. But you're also cap exempt if you work for a cap exempt employer. Meaning if you have an employer who is a nonprofit research organization or a government research organization or an institution of higher education. So then you will be cap exempt because those institutions don't need to file under the cap. Now, you don't have to be directly working for them. They could be an end client as well. You could be working for a consulting company, and the end client could be one of these companies. In that instance also, it is an exempt organization, and your H1B will be an exempt petition.
Thank you. We do actually have one more question from Ashishta. H1B filing with the one client letter and later for traveling with another client project letter, SAW/PO. Will there be any specific questions at the port of entry? How do we handle that?
Well, at least until last year, the consulate was willing to look at any kind of work that you had, even if it was not the client that you submitted at the time of the H1. If you're able to show that that existed, but later on the requirement was rescinded, and now you have a new requirement as long as it's in the same work location, etc., and meets the other requirements of the LCA, they were willing to look at those letters and approve visas based on those letters. So recently, I haven't seen anything happening otherwise, but you can expect that there will be more extreme vetting at the consulate and the POE as well, at the port of entry as well. But as of now, they should accept it even if there's another client, as long as you're able to show that at the time of filing the petition, there was a bona fide job offer. That's important. And that the job has now changed, as long as it's not a material change, they should still accept it, is what I'm thinking as per the law. But as you know, the officers at the port of entry have complete power over whether they allow someone in or don't. So they could be unreasonable about it also. But as per the law and as of now, as long as you're able to show bona fide job offer at the time of filing, and you show that right now there is no bona fide, that job offer lapsed, and there is a new bona fide job offer, that should still be fine.
All right. Thank you so very much for answering all these questions. Another very insightful session. And thank you so much for everyone joining today on multiple different streaming platforms. We would be continuing to host our webinar series in streaming platforms. So do join us for the next one. And Prashanthi, once again, thank you so very much. We will be announcing the date for the next webinar very soon. Hope to see you there.
Thank you. Thank you very much, everyone, for joining. I hope the session was useful for you, and please tune in for other more useful sessions. We will, as Vishal said, be announcing another one. We'll have another one for next month. Thank you.
Thank you, everyone.